Hi, my name's Isaac Shutt. I'm an estate planning attorney and probate attorney. I'm licensed both in Texas and in Wyoming. Today I'm going to talk about affidavits of heirship. What is an affidavit of heirship? Well, an affidavit of heirship comes into play after a person has passed away, and it deals with transferring property, and more specifically, real property or real estate. So where this really comes into play is where a person, like a loved one, has died, and really all they had in their name was a piece of real estate. Maybe it was their home, maybe it was an investment property, but they had a little bit of land or real estate ownership that needs to get transferred to the heirs. And so the affidavit of heirship is actually, it's labeled non-judicial evidence of heirship. And so that's different from a determination of heirship, which is where you actually go to a probate court and get a document signed by a judge legally determining who the heirs are, whereas the affidavit of heirship is non-judicial, meaning it didn't go through court. So even though it's really confusing because you have affidavit of heirship and determination of heirship, they are not the same thing at all. So an affidavit of heirship doesn't go through court. Determination of heirship does. Now, in a separate video, I'll talk about determination of heirship and when that's applicable and when that's better, but this video is just about the affidavit of heirship. Okay, so when a person has died and really all they had in their name is a piece of real estate, no bank accounts without beneficiary designations, no other assets to speak of, well, the affidavit of heirship could be a good way to go. The way it works is two disinterested witnesses, so people that have no financial bearing in who's getting property, those two disinterested witnesses would sign an affidavit that lays out the family and marital history and descendant history of the deceased person. And then by operation of that, the affidavit of heirship says, okay, based off this family history, here's who the heirs would be. You're not required to have an attorney prepare affidavits of heirship after a person passes away. And so if the affidavit of heirship is a good way to go, there are forms online and things like that. You know, I will tell you, just to be totally blunt, most of the DIY affidavits of heirship I've seen are wrong because they don't lay out the family or marital history of the deceased correctly. And that can be a big problem when it comes to titling real estate. So it is usually better to go see a probate lawyer to do affidavits of heirship. And then also sometimes title companies will prepare affidavits of heirship and they're pretty good at them and do a good job. It's worth the minimal amount of money it takes to get affidavits of heirship done just to pay a professional to have it done for you. That way you know it's right. And that's really important with an affidavit of heirship because with this non-judicial evidence of heirship, the law, Texas law, says that it doesn't really do anything until it's been on file for 5 years. So it's not non-judicial evidence of heirship until the affidavits of heirship have been filed in the real estate record and hasn't been contested for a period of 5 years. And honestly, that 5-year thing where it's got to be filed for at least 5 years, for a lot of people, that's a deal breaker. You know, they say, look, Isaac, my mom passed away. I'm the only child. So under the affidavit of heirship, it's going to say that I'm the sole heir to the estate. Why wouldn't I want an affidavit of heirship? And my response would be, well, if you're wanting to sell it pretty soon, and you don't want to wait that 5-year period, then the affidavit of heirship may not be the way to go. Affidavit of heirship works really well when I have like a married couple, and if the other spouse, the surviving spouse, will be inheriting everything under that affidavit of heirship, and they're going to continue to reside in that home for a long period of time. Sometimes an affidavit of heirship would work really well, but that 5-year thing where it needs to sit in the record can be a deal breaker. Now, I will tell you that 5-year rule where the affidavit of heirship needs to sit there, Not all title companies require the seller of a piece of real property to wait that full 5-year period. So it really just depends on the title company and the title underwriter when you go to sell that deceased person's property. And therein lies another problem with the affidavits of heirship. They don't have to be accepted. So if you are planning to sell your deceased loved one's property and you're going to use that affidavit of heirship with the title company, what can happen is you can get all the way till days before closing, and then the title company, just without a lot of pomp and circumstance, will tell you, I'm sorry, we've just heard back from the title underwriter that they won't even accept your affidavit of heirship. And so you've gone through this hassle of paying money to have affidavits of heirship prepared and signed by witnesses, only to find out right before your closing that it's not going to be accepted to transfer title to whoever that buyer is. And that creates a problem for you because that buyer has a contract with you. You promised to deliver good title to that home, and you thought you were all good to go, and now that you came to a day before closing and you're not going to be able to close with that title company, you're potentially in breach of contract because your contract says you're going to deliver good title that next day, and you're not going to be able to do that. So affidavits of heirship in a lot of cases are really risky. So you've got some clients who say, Isaac, I'm a gambler. Let's just go with the affidavits of heirship because it's less money. And if the title underwriter doesn't accept that the week before I close, I'm okay with that. I'll just deal with whatever the breach of contract issue is at that time. I'm good with that because the affidavit of heirship is so much cheaper than any of the other options. I'm willing to roll the dice on that. And then we have other clients that say, you know what, for the relatively small increase in cost, I'd rather deal with guarantees. I don't want to deal with maybe this works and maybe I won't be in breach of contract with this affidavits of heirship thing. I want something that's a guarantee. Well, if you want something that's a real guarantee, then the affidavit of heirship, even though it's less money, is probably not what you want. So it's really a case-by-case thing, depending on what surviving family members there are, what property there is. And then also, like I said, if there's anything other than that piece of real estate, that affidavit of heirship's not going to work. So like, for example, if the deceased person had a bank account that didn't have a beneficiary designation, you're not going to be able to use affidavits of heirship to get into that bank account. The affidavit of heirship document is a real estate document. Anyway, I've probably given you more detail than you even wanted to know, but I hope you found this video helpful. It's been all about affidavits of heirship. In some other videos, I'm going to talk about determination of heirship and then also a small estate affidavit. And again, my name is Isaac Shutt. I'm an estate planning and probate attorney licensed both in Texas and in Wyoming.